On Tuesday, August 26, 2025, a federal judge delivered a decisive ruling that dismissed an extraordinary and unprecedented lawsuit filed by the Trump administration against all 15 federal district judges in Maryland. The lawsuit, initiated by the Department of Justice (DOJ) in June 2025, sought to challenge a standing order issued by the U.S. District Court for the District of Maryland that temporarily halted deportations of immigrants who filed habeas corpus petitions to contest their detention. The ruling, penned by U.S. District Judge Thomas Cullen, a 2020 appointee of former President Donald Trump, not only rejected the DOJ's attempt to curb the judiciary's authority in fast-moving immigration cases but also framed the lawsuit as a significant constitutional clash between the executive and judicial branches of government. In a scathing 39-page opinion, Judge Cullen described the lawsuit as novel and potentially calamitous, arguing that it represented an overreach by the executive branch and a direct challenge to judicial independence. The origins of this legal battle trace back to May 2025, when Chief Judge George L. Russell III of the Maryland Federal District Court issued a standing order in response to a surge of immigration-related habeas corpus petitions. These petitions, often filed by immigrants facing imminent deportation, alleged wrongful detention and sought judicial review. The standing order mandated a 2-day stay on deportations for any detainee who filed such a petition, aiming to preserve the court's jurisdiction, ensure access to legal counsel, and allow the government sufficient time to present its defense. The order was a direct response to the Trump administration's aggressive immigration policies, which included rapid deportations that critics argued circumvented due process. The high-profile case of Kilmar Abrego Garcia, a Salvadoran immigrant living in Maryland who was wrongfully deported to El Salvador in March 2025 despite a 2019 immigration court ruling prohibiting his removal, underscored the tensions. Abrego Garcia's case, overseen by Maryland Judge Paula Shinnis, highlighted the administration's pattern of deporting individuals even in the face of judicial orders, prompting the court to implement the standing order to prevent similar incidents. The Trump administration, through the DOJ, argued that the Maryland court's standing order was an egregious example of judicial overreach that interfered with the executive branch's constitutional authority to enforce immigration laws. In an unprecedented move, the DOJ filed a lawsuit in Baltimore against all 15 Maryland federal district judges, the court itself, and its clerk, seeking to block the standing order. The complaint asserted that the automatic 2-day stay violated Supreme Court precedent on issuing injunctions and flouted congressional intent. The administration claimed that the order hindered President Trump's ability to execute immigration policies, particularly in light of the roughly 250 lawsuits challenging his executive orders. A spokesperson for Attorney General Pam Bondi described the lawsuit as an effort to rein in unlawful judicial overreach, emphasizing the administration's commitment to preserving executive power. The lawsuit drew immediate and widespread condemnation from legal experts, Democrats, and even some retired federal judges, who viewed it as a direct assault on the judiciary's independence. Maryland Governor Wes Moore issued a statement calling the action a transparent effort to intimidate judges and usurp the power of the courts. Legal scholars, such as Lori Levinson of Loyola Law School and Stephen I. Vladeck of Georgetown Law, described the lawsuit as unprecedented, noting that they could not recall another instance in U.S. history where the DOJ, which typically defends judges in court, sued an entire district court bench. The move was seen as part of a broader pattern of the Trump administration's confrontational stance toward the judiciary, which included public attacks on judges who ruled against its policies. Over the past several months, Trump administration officials and their spokespersons had labeled federal judges as left-wing, liberal, activists, radical, rogue, unhinged, and crooked, fueling a narrative that critics argued undermined public trust in the judicial system. Because the lawsuit named all 15 Maryland judges as defendants, they were forced to recuse themselves, necessitating the appointment of an outside judge to preside over the case. Judge Thomas Cullen, based in the Western District of Virginia, was selected to oversee the proceedings in Baltimore. Cullen, a former prosecutor appointed by Trump in 2020 with the support of Virginia's Democratic senators, brought a unique perspective to the case. During a hearing on August 13, 2025, Cullen expressed skepticism about the DOJ's approach, questioning why the administration chose to sue the entire Maryland judiciary rather than pursue a traditional appeal in one of the affected cases. "I don't have a very good poker face," Cullen remarked, signaling his doubts about the lawsuit's legal grounding. He suggested that the administration's arguments, while potentially valid in a different context, were misplaced in a lawsuit targeting an entire judicial body. In his ruling, Cullen delivered a comprehensive rebuke of the Trump administration's tactics. He argued that the DOJ lacked the legal standing to bring the lawsuit and that the judges were protected by judicial immunity, a well-established principle that shields judges from being sued for actions taken in their official capacity. Any fair reading of the legal authorities cited by defendants leads to the ineluctable conclusion that this court has no alternative but to dismiss, Cullen wrote. He emphasized that the lawsuit represented a constitutional free-for-all that pitted two co-equal branches of government against each other in a manner that was both unprecedented and contrary to constitutional tradition. Cullen underscored that the judiciary's role is to act as a check on the executive branch when its actions violate the law, and he criticized the administration for attempting to smear and impugn judges who ruled against it. The ruling highlighted the availability of alternative legal avenues for the Trump administration to challenge the standing order. Cullen noted that the administration could have appealed the order in one of the specific cases where it was applied, a tried-and-true recourse available to all federal litigants. This approach, he argued, would have been far less confrontational and more consistent with established legal norms. Legal experts, such as James Sample, a constitutional law professor at Hofstra University, echoed this sentiment, pointing out that the administration's decision to sue the entire Maryland bench was a deliberate escalation rather than a necessary legal strategy. Sample noted that the standing order itself was a reasonable response to the administration's actions, which included moving detainees to prevent them from accessing habeas corpus relief. "The judges here didn't ask to be put in this unenviable position," Sample said. "Faced with imperfect options, they have made an entirely reasonable, cautious choice to modestly check an executive branch that is determined to circumvent any semblance of impartial process." The case of Kilmar Abrego Garcia served as a focal point in the broader dispute. Abrego Garcia, a Salvadoran national with a U.S. citizen, wife and son, was deported to El Salvador in March 2025 despite a prior immigration court ruling that he faced persecution if returned. His wrongful deportation, which the DOJ later attributed to an administrative error, led to weeks of legal battles before he was returned to the U.S. on June 6, 2025. Upon his return, Abrego Garcia was taken into Immigration and Customs Enforcement (ICE) custody in Baltimore and faced new criminal charges and another deportation attempt, this time to Uganda. On August 24, 2025, Judge Paula Shinnis, one of the Maryland judges named in the DOJ's lawsuit, issued an order prohibiting the government from deporting Abrego Garcia while his case was pending, citing the standing order's protections. This incident exemplified the tensions between the administration's rapid deportation efforts and the judiciary's efforts to ensure due process. The Maryland Federal District Court, where 13 of the 15 judges were appointed by Democratic presidents, had become a significant battleground for immigration-related litigation. In addition to Abrego Garcia's case, Judge James K. Bradar was handling a lawsuit filed by Democratic attorneys general alleging that the Trump administration violated the law by terminating probationary federal employees without notifying local officials. Judge Stephanie Gallagher was overseeing a case involving the rights of unaccompanied minors deported under Trump's invocation of the Alien Enemies Act, and Judge Brendan A. Herson had ruled that Trump's executive orders on gender were illegally denying medical care to transgender youths. These cases, among others, highlighted the judiciary's role in checking the administration's policies, which often pushed legal boundaries. Cullen's ruling was supported by a coalition of legal advocates, including the Maryland State Bar Association, dozens of law firms, and 11 retired federal judges who filed friend of the court briefs defending the Maryland judges. Paul Clement, a prominent Supreme Court advocate and former Solicitor General under President George W. Bush, represented the Maryland judges and argued that the lawsuit was an impermissible attack on judicial authority. "There really is no precursor for this suit," Clement said during a court hearing, emphasizing that the executive branch had no legal basis to sue a co-equal branch of government. Retired federal Judge Philip Crow, appointed by President Ronald Reagan, called the Maryland court's standing order a sensible step that was well within the judiciary's authority to manage its docket and ensure due process. The White House responded to the ruling by claiming that it was a direct assault on President Trump's ability to enforce immigration laws. However, legal analysts argued that the dismissal of the lawsuit was a significant victory for judicial independence and the rule of law. Alan Rosenstein, a former DOJ official and law professor at the University of Minnesota, noted that the lawsuit reflected a deeper breakdown in trust between the executive and judicial branches. The fact that Judge Russell had to put the measure in place to begin with suggests just how bad things had gotten, Rosenstein said. The ruling also drew attention to the broader context of the Trump administration's immigration policies, which included a Supreme Court decision in June 2025 that allowed the administration to resume deporting migrants to countries other than their own with minimal notice, a move criticized by Justice Sonia Sotomayor in a dissenting opinion as rewarding lawlessness. Cullen's opinion included a pointed footnote addressing the Trump administration's rhetoric against the judiciary. He noted that administration officials had repeatedly described federal judges as left-wing, radical, and unconstitutional, among other derogatory terms. Although some tension between the coordinate branches of government is a hallmark of our constitutional system, this concerted effort by the executive to smear and impugn individual judges who rule against it is both unprecedented and unfortunate, Cullen wrote. This criticism from a Trump-appointed judge underscored the gravity of the administration's actions and their potential to erode public confidence in the judiciary. The dismissal of the lawsuit does not mark the end of the broader conflict between the Trump administration and the federal judiciary. With over 200 lawsuits pending against Trump's executive orders, the courts remain a critical battleground for challenges to his policies. The case of Kilmar Abrego Garcia continues to unfold, with Judge Shinas overseeing his ongoing legal battles to remain in the U.S. Meanwhile, the Maryland standing order remains in effect, providing a temporary shield for immigrants challenging their detentions. Legal experts anticipate that the administration may pursue appeals in individual cases to challenge the order, as Cullen suggested, but the dismissal of the DOJ's lawsuit against the Maryland judiciary sets a significant precedent for protecting judicial independence. The ruling has broader implications for the separation of powers and the role of the judiciary in checking executive actions. By rejecting the DOJ's lawsuit, Cullen reaffirmed the principle that the judiciary is a co-equal branch of government with the authority to review and, if necessary, restrain executive actions that violate the law. The case also highlighted the challenges of navigating complex immigration issues in a politically charged environment, where the executive branch's aggressive policies have tested the boundaries of constitutional governance. As the Trump administration continues to push its immigration agenda, the judiciary's role as a guardian of due process and the rule of law will remain critical, ensuring that the constitutional balance between the branches is maintained.